few of the questions would be addressed through the webinar only, because we'll be talking about the road accident cases and other stuff. So this is what is hunting. Let's elaborate on hunting. Let's next slide. So yes, I just like you read at the clause A, killing or poisoning. So mere killing of a wild animal, obviously that would, when it's an actual killing of a wild animal, so that would amount to hunting. It can be killed through firearms, it can be killed through spears, it can be killed through arrows and bows. So it can be done through various process. A wild animal can be killed, and the other is poisoning. Next slide. What is killing or poisoning? Then the poisoning thing. On the right side of the screen, you can see it's a very famous case from South India, wherein a pregnant elephant was actually killed by feeding her a pineapple, which was having explosives. So, pineapple laden with explosives was actually fed to a pregnant elephant. A very sad case, very horrifying case. So this is a modus which is also, employed by the criminals, the miscreants who are indulging into wildlife crimes, primarily the hunting. So explosives, using of explosives in killing wild animal is also a common, is also one of the modus operandi employed by the criminals in India, and I guess in other parts of the world as well. So this is a picture from South India from last year, where the explosives were used to kill a pregnant elephant. And on the left hand side of your screen, you can see this picture wherein an elephant has been killed through electrocution. So killing can be done through electrocution, through explosives, through firearms, through arrows and bows, through traditional, tribal methods of using arrows and bows, and through, firearms are very much common, uh, which are used by the professional hunters. Next slide. Killing or poisoning. So poisoning is one of the, you would see in India that many people, in order to save their fields from standing crops from the wild animals, because wild animals would venture into the fields and would damage their fields. So the in the rural parts of India, you will come across such cases wherein the animals are actually, given poison food for predators. The villagers in many parts of our country would actually put poison in the flesh of a dead cattle. The tiger or the leopard would come and would eat that carcass, which is poisoned by the villagers. And then this is how the death occurs. So poisoning is a very common modus employed in India, but in the rural parts of India, to kill a wild animal. So that's why poisoning has also been incorporated in the definition. That's one of the most common, you would see, modus to actually kill in the rural parts of India, in order to save the attacks of wild animals in the field, and in order to save the standing crops. So poison is another. So, and in other parts of the world, you can see this cyanide poisoning, which is there, which is used to eradicate the menace of wild animals venturing into the fields and the standing crops. So this is more prevalent in the other parts of the world. In India, you would see a lot of poison in the dead cattle, which the villagers would put. Next slide. So that's the first clause A when we talk about killing and poisoning. The second limb of the definition hunting talks about capturing, coursing, snaring, trapping, driving, or baiting. So these are 6 different acts which would also amount to hunting in India, whether the animal is killed or not. It's a simple case wherein an animal is captured, where an animal is captured through snaring, the animal is trapped through another through some other instruments which are very much common for trapping of the wild animals and capturing. So you see, in all these acts which are mentioned on your screen, forms the second limb of the definition of hunting, the clause B of the definition. And you will see that in most of this, almost in all of these acts done by the humans, the animal is not killed. So, what can be inferred from the definition, the clause B, that even when the wild animal is not killed, it's mere captured, it's mere trapped, and is baited and then again captured. So, baiting would be for capturing and then finally killing, driving the animal to take some path and then they are captured and then finally maybe killed or not. But the intention of the parliament, the intention of the law is very much clear that the initial acts of capturing, coursing by using that hound dogs, you capture wild animals. So a mere capturing of the wild animal, and for whatsoever reason the capturing is done, it's not only for hunting of the wild animal, maybe to live animals, or maybe out of love, even if somebody captures a wild animal, let's say, because the law here is very much silent about the intention and knowledge. It's a strict liability act. What is a strict liability offense? Wherein your intention and knowledge has no role to play in order to prove your guilt before the law. The law would not go into your mental status. What was your intention to capture the animal? What was your intention or knowledge on your part to capture or bait a wild animal? Even if you are very much in deep love with wildlife and you just want to interact with the wild animals by capturing them, the law would not permit it because it's a strict liability offense. Once the act is done, the law would not go into the intention of the criminal or the knowledge which he possesses. So it's a strict liability offense. So this is the second link. Next. So this is coursing. People use hound dogs, we all know. This is coursing, even this is prohibited. If somebody course wild animal to take some path and then later on, with the aid of hound dogs, they are killed or maybe they are captured for the illegal trafficking or for whatsoever purpose. The law hasn't gone into that detail. A mere coursing of wild animal would actually amount to hunting. Next slide. Baiting. So yes, this is also very much common. You can see in the Western world, baiting of the bears are very much common. So they are baited with food and then they are captured. And then it's with the antelopes as well. So baiting is also part of the hunting definition. If somebody does any kind of baiting to a wild animal, a mere baiting, whether the animal is attracted or not, doesn't matter. Even an attempt to bait would be covered under the definition of the hunting. So this is baiting. Next. This is now the third limb of hunting. So first, let's have a short recap. Killing and poisoning is very much, commonsensical, that somebody is killing a wild animal through various, which we have talked about, various methods, whether it's electrocution, whether it's through firearms, whether it's through explosive, and then poisoning, which have been separately mentioned in the clause A, poisoning of wild animal, because by that eventually either the animal would be dead by consuming the poison, or may become incapacitated through various reasons of consuming poison. Now, this third part is about injuring the wild animal or destroying, taking away any part of the wild animal. That is the limb 3 of the definition of hunting. So, you would say there are people who would actually not kill the wild birds or wild animals, and they would only simply take part of such animal. So that would also amount to hunting. Now you see the beauty of this definition. Somebody is killing a tiger with a firearm. It would amount to hunting. The punishment would be same as that of taking any part of a wild animal. Let's say a parakeet, the feathers are plucked So it would also amount to hunting. It's at the same footing as that of killing of a big predator like a tiger, Bengal tiger, or a leopard, or a Asiatic elephant. If they are hunted through firearms or other methods, and if there is a parakeet or a peacock which has been, not killed, but merely their feathers are plucked, so that would also amount to hunting. These acts, all the acts are at the same footing. So it's not that only the major animals have been accorded protection, and it doesn't matter whether the animal is killed or not. If the animal is captured, it's an offense. If the animal is not, it's captured for a short while and then the feathers are plucked of a wild bird, that would also amount to hunting in the definition which we have under the Wildlife Protection Act. So this is injuring the animal or destroying or taking any part of any wild animal, which is usually you would see happens with the wild birds which we have in India. Next slide. Now the last limb, that is about damaging the eggs of birds or reptiles, disturbing the eggs or nest of such birds or reptiles. So this is about the birds and reptiles. So any act towards damaging the eggs or mere disturbing the nest of wild animals, leave the killing of wild birds, leave taking away the eggs, a mere damaging or a mere disturbing. So no, so even if a person has not taken the eggs but have damaged it through some physical act or have disturbed the eggs which were there in their natural state, how the mother have kept them to be laid with course of time. If somebody damages that natural course, the way the eggs have been kept, or damage or disturbs the nest of the eggs, so that would also amount to hunting under the local law which we have, the Wildlife Protection Act. And it does not only accord protection to the eggs of the birds but also of the reptiles. Next slide. So what all we have discussed till now was the definition of hunting, that what is hunting under the Wildlife Protection Act. Now, under what provision the hunting is prohibited? That section 9 of the Wildlife Protection Act, which says that there is prohibition of hunting of wild animals if that wild animal is a scheduled animal mentioned in the Schedule 1 or Schedule 2 of the Wildlife Protection Act. So that is completely prohibited, but it's a general rule and there is an exception. So we'll see that first we have already seen that what is hunting, and now section 9 say it is prohibited. So hunting is prohibited in India when it comes to hunting of animals which are mentioned in Schedule 1 and Schedule 2 of the Act. So you see all this Bengal tiger, the Asiatic elephant, leopards, and other animals, gangetic dolphins, etc. So all these you would find in the Schedule 1 and Schedule 2 of the Wildlife Protection Act. So it's a prohibition. So it's prohibited to hunt such wild animals which are incorporated in the schedules. There are exceptions. The law always carve out some exceptions, and it is not a blanket ban on hunting in India. So there are a few exceptions which you will see on your screen. The last sentence of the content, except as provided under section 11 and 12. So there are two sections which are exceptions to the hunting, else hunting is very much prohibited in India. Apart from section 11 and 12, no one can hunt and there is a punishment given as to which schedule the animal belong which has been hunted. So it is prohibited. Now we'll come to the exceptions. Next slide. So now before going to the exceptions, and as we have already discussed what is hunting, and I read somebody talking about the road accident. So I'll first take that question because that may be relevant to the case law which we're discussing. Okay, so Mr. Vineet Bhatt asked, would an animal killed in road accident on national highway come under the purview of hunting? So yes, precisely this is what we will be now discussing. It's a case from the Karnataka High Court. To all the participants who are not aware about Karnataka, Karnataka is a state in South India, and we have a constitutional state high court in all the states. So Karnataka High Court had the opportunity to discuss and to explain the definition of hunting in this very case. The case is titled Abhishek versus State of Karnataka. So the facts in brief of this case is that this Abhishek, the petitioner before the High Court, was driving through a wildlife sanctuary in Karnataka. There is a public highway which runs through the wildlife sanctuary in Karnataka, and while he was driving at the wee hours of night, uh, his car crashed into a leopard which was crossing that highway road which runs through the wildlife. So he was going from one side to the other side of the road, and while crossing the public highway, the leopard met with an accident. The car belonging and driven by Abhishek was crashed into the road. The leopard died at the spot after sustaining fatal injuries. The vehicle and this accused Abhishek was arrested by the Forest Department of Karnataka, and the case of hunting was brought against Abhishek before the criminal court, the concerned criminal court. Now, to challenge the entire criminal proceedings, which can be done before the High Court, Abhishek went straight to the Karnataka High Court, and here he had the contention that look, number it's a road accident and the leopard, I had no intention or knowledge to kill that leopard, and it's a mere road accident under which the this unfortunate act of leopard getting killed happened by my car. So there is no intention on my part, there was no knowledge on my part, so thereby I should be set free, I should be exonerated from all the charges, and this criminal case brought against me by the Forest Department of the Wildlife Sanctuary should be quashed, should be closed. So here in this case, the Karnataka High Court had the opportunity to go through the relevant provisions and to explain what amounts to hunting. And you would see that in the middle of this content, the word used by the Karnataka High Court, which is mentioned in the red strict meaning. So the court deliberated upon the intention of the law, the intention of the parliament when this provisions of hunting were actually passed by the parliament. So what the High Court explained and inferred through the words of the law was that a strict meaning has to be given to the definition of the law, because if you read the definition of hunting under section 2 clause 16, which defines hunting, there is no use of word intention, knowledge, mens rea, somebody deceitfully does something, somebody out of malice is killed. So there is no mental element which is a prerequisite, which is actually an ingredient to invoke the penal provisions of hunting. So the court held that strict meaning has to be given by your conduct of driving over the highway, which you are very much aware that it's a wildlife sanctuary, and very often the wild animals at night would cross such highways, would go from one part of sanctuary to the other part, and in between there are public highways, and they would cross that road. So some kind of a prudent man is expected to drive carefully. And what went against Abhishek in this case was that he was over speeding. He was driving his car beyond the speed limit which was prescribed on the public highway, which ran through that wildlife sanctuary in Karnataka. So that went very much against him. So the court said there is some knowledge on your part, and it's a strict liability offense. Once by act of driving a car at speed beyond the legal limits, you kill a leopard, we are not going on the intention which you had. We know that you had no intention to actually kill the leopard, but because you were driving beyond the speed limits prescribed, and it's a strict liability offense where we will not see whether you had the knowledge to kill the leopard or not, whether you had the intention to kill the leopard or not. The law will go on that. It's a strict liability offense. So his petition to close the trial court matter before the concerned district court was quashed. His prayer before the High Court was quashed, and the matter was remanded back to face trial. So, from this judgment, what we have already discussed is that it's a strict liability offense. So, strict meaning is to be attributed to the letters of the law. If it's written that there is no intention or knowledge required on the part of the accused, nobody can take that defense that, look, I had no intention. For example, you go to the national park where you find a leopard cub, and you, out of the love for wildlife, you go and live that leopard cub in the absence of his mother. And you are simply just out of affection, you just want to cuddle that cub and you just live that leopard cub. But that's actually capturing of a wild animal which is there in wild. So you cannot later, if in case a case is brought against you, you can't later on bring this defense that, look, I had no knowledge to capture the leopard cub. It is just out of love and affection for the wildlife that I lifted that cub and took in my custody. So yes, so these are all strict liability offenses in India. Like we have narcotic laws, we have other special laws, customs laws, wherein no intention or knowledge is required to be proved. So yes, so this is this Abhishek versus State of Karnataka on the strict liability. Next slide. Another important and very interesting case. So whosoever is from India would have heard this festival of Hindus called Nag Panchami. So in various parts of India, particularly in Maharashtra, there are communities who would actually capture live snakes like dhamans and cobras from the adjacent forest areas which they have near their villages. They would capture the live snakes, they would bring them home, and they worship the live snakes. They would feed them with milk, would worship them with all clean intentions, because for them these snakes are gods. And so this is the festival of Nag Panchami for people who are not from India. That in few parts of our country, the Hindu community we have would capture the live snakes, would bring them home, would worship them, would feed them milk, and would very safely set them back to the jungle, would free them back into the jungle. But all these customary these acts are very much against the Wildlife Protection Act and the laws of hunting which we have. So this case is about that only, wherein law and religion came face to face. It's a case from Bombay High Court, and the case is about a Gram Sabha which challenged the government notification. So one fine year back in 2014, during the Nag Panchami festival, much before the festival date, the forest officials brought a notification, you can say a policy, a direction to the local people of that Gram Sabha in Maharashtra, that from this year onwards, during the festival of Nag Panchami, the village people are directed not to capture live snakes, because these are scheduled animals. These are scheduled, given protection under the schedules of the Wildlife Protection Act. So these scheduled snakes should not be captured, should not be brought back to the villages, should not be harassed, should not be fed with milk or other stuff. If somebody is doing any such kind of capturing and bringing them from jungle to their homes, such people would be prosecuted under the rigors of Wildlife Protection Act, and such capturing also amounts to Section 9. Now, aggrieved by the order of the Forest Department of capturing such wild animals, the Gram Sabha, some village people approached the Bombay High Court and they challenged this notification of the Forest Department, whereby they were restrained from capturing such snakes and for taking them back home for worshipping. So there were two contentions of the village people which they brought before the Bombay High Court. Number one was that the capturing of the wild snake were for good purpose, and it was a temporary capturing. They would capture them in the morning and they would set them free in the jungle by the evening once the puja, the rituals are completed, are concluded. The animals, the wild snakes would be set free. So there is no harm which is caused, or it is not. It would not amount to hunting or capturing of the wild snakes. They are only capturing it for the noble cause, for their this tradition of capturing and for worshipping. So it's all in bona fide, in good faith, they are doing everything. Number second, the contention of the villagers were that they have the right to practice their religion, which is guaranteed under the Constitution of India. They have their fundamental right to propagate, to practice the religion without any restriction. So, Bombay High Court, after going through the entire conspectus and after going through the provisions of the Wildlife Protection Act, observed number one, the first contention was brought down by the Bombay High Court of the villagers. The court, after going through the definition which we have already discussed, the court held, which is there on the pointed to before your screen, the court observed that the fact that the capturing is for temporary basis makes no difference. So whether the capturing is for 5 minutes or 5 hours or for the entire life of that animal, the animal is captured, doesn't matter. Animal is captured, even if it's captured for 5 seconds, it is in the custody of human being, that would amount to hunting. The court made it very clear that the law does not provide that the capturing should be for at least 5 hours or 5 minutes. So a mere temporary capturing of the wild animal would amount to hunting. So the first contention was brought down. So what we can understand from this judgment is that somebody who's capturing even for a short time, so that capturing would amount to hunting and the person can be punished for the offense. Nobody can take this defense that the capturing was for 5 minutes and the capturing was for the good purpose. We worship snakes, so that's why we are not killing them, we are not selling them, we are not doing, we are not indulging into illegal trafficking of the wild snakes. Doesn't matter at all whether what the cause is, because the law, again on the cost of repetition, I'm saying the law is not going into what intention accused has. Intention and knowledge plays no role in the Wildlife Protection Act. So this first contention was gone, and then later on the second contention, which was about that it's our fundamental right. So the court again uh, brought down the second contention, and the court said that it is not the integral part of the Hindu religion. There are people in the other parts of India who would simply buy a picture of a snake or a sculpture of a snake, and they would actually worship on the of the snake posture, and they will worship the Naga Devta, the snake gods which we have in India. So it is not the prerequisite, or it is not mandatory, or it is not the intrinsic part of our religion that we have to actually capture the snakes, the animals which are protected under some law. So in order to simply exercise your customary rights, which was prevalent in Maharashtra in this case, so just to practice your customary rights, which is there from long. But if that customary right, the customs which you have, is violating the laws and it's actually causing trauma to the wild animal and is actually attracting the penal provisions, the criminal provisions of any law, so that cannot be done. And we cannot carve out any exception that somebody requires it for the rituals and it's part of their religion. So law does not carve out any such exception. So both the contentions were brought down. What we can learn from this judgment: number one, whether capturing, trapping of a wild animal in illegal custody, whether it's for 5 seconds, 5 hours, 5 days, 5 years, doesn't matter. Once the act of capturing is done, it is an offense. And it should be an offense. If the attempt to capture has been made an offense in the Wildlife Protection Act, and that also amounts to hunting. So a mere attempt to capture is an offense, then the capturing for 5 seconds would definitely be an offense. So this is what we learned from this judgment from the Bombay High Court. Next slide. So yes, so these were the two judgments which talked about the hunting, what amounts to hunting, and how the laws have been interpreted by various state high courts in India. Now talking about hunting of wild animals, whether they are permitted or not in certain cases. Yes, they are very much permitted, and you can take a screenshot if you want. These are the exceptions. This is the first exception which has been carved out under the Wildlife Protection Act when the animals can be hunted. So to start with, hunting of wild animals, um, when it can be permitted, when a wild animal is declared dangerous to human life, the hunting by the government can be permitted. For example, and why word uses dangerous to human life, not man eaters, because elephants are not man eaters, but they can very much be dangerous to human life. Same as with the Asiatic sloth bear, they can be dangerous to human life for some reasons. But just a second. But yes, so that's why, and dangerous to human life involves the man-eater predators which we have in India, mostly in the Himalayan state of Uttarakhand, the man-eating tigers and the man-eating leopards. So the first exception is when the animal is actually turned dangerous to human life. And how it can be ascertained, there is proper legal inquiry which is gone into by the forest department of the concerned area, and then they declare through the conduct of the animal as to how many humans he has killed, and whether it's happening repeatedly. So there's a thorough inquiry done about the animal and his conduct, and the fatalities which have been caused by the acts of that very wild animal, and then later on a legal order can be passed to hunt down such animal or animals. So dangerous to human life, the very first exception under the Wildlife Protection Act, the animal can be hunted. Number second, it's disabled. So the animal is living a life in agony, in sorrow, in pain, and no purpose would be solved, and there cannot be, there is no recovery. So the damage is irretrievable. So the animal is actually living in agony and pain. So that animal can be slept forever, can be, uh, killed through measures which requires the least pain, I would say. So by that, the animal can be killed if it's very much disabled and in pain and agony. The third is it's diseased and it's beyond recovery. So you would see there are animals who contract such diseases again. They may live a life in utmost sorrow, in utmost agony, pain. So such animals can also be hunted, which means they can be killed in order to prevent them from suffering with more agony and pain. And also, there are animals which would contract diseases and viruses, which is communicable disease and can spread over to other animals. And it is very much, detrimental to the wildlife habitat in which that diseased animal is actually living. So there is a case, the very famous case from Gujarat many years back. The Asiatic lion contracted some disease which was communicable, and I think almost 100 Asiatic lions got killed through that disease, which was contracted by few lions initially. So, in such a scenario where it can be detrimental to the habitat, to the other animals, there is a diseased animal, so that diseased animal can be, killed, can be slept forever. So these are the situation. Now you see there is one difference. I have mentioned the in these two tabular comparative tables. Schedule 1 has 3 exceptions. However, the Schedule 2 animals, which are you would say have some less you can say importance in the ecological balance. Like tiger, leopards have been kept at a very high, this table when it comes to their importance in the ecological balance. But there are some small animals which do have a lot of ecological importance, But then again, in law, they have been kept in Schedule 2, and they can very much. For example, we have wild pigs. So the wild pigs, the wild boar can are in Schedule 2. So you would see for that the law says even if not only dangerous to human life, they are causing a lot of damage to the standing crops. So the humans would face a loss of this all the cultivation, this agriculture activities would suffer with huge losses if such animals are actually not hunted down or are captured. So including standing crops. But see, tiger comes in Schedule 1. So if somebody is agitated by tiger damaging the standing crops, so the tiger cannot be hunted down because it's a mere standing crops, and on the other side it's a Schedule 1 very important Royal Bengal tiger, which have been kept in Schedule 1 with more and with more protection under Schedule 1. So for Schedule 1 animals, standing crop is not the reason to hunt them down. And please mind that when I say hunt down, so please refer to the definition. Hunt down does not mean that in all the such circumstances which are mentioned on your screen, the animal is actually killed. No. Hunting, as you remember, we have discussed, also talks about capturing. So these animals, even if they are dangerous to human life, and I'll discuss from the next slide that yes, hunting, as we all know, means capturing of the wild animal as well. So even if the government is taking such steps of hunting down a man eater, so that does not mean that straight away a bullet would go in the head of a tiger, which has turned man eater as per the government. So that implies hunting implies that that animal has to be captured. Next slide. So yes, as I already told you that the exceptions which we have seen, and talking about the biggest reason you would see that the legal hunting, the permitted hunting under Section 11 happens in India. Most of the cases are where the animal have turned dangerous to human life, where the animals have turned man eaters, like we have predators in Himalayas, they have turned man eaters. So then you see most of the hunting orders are related to the clause 1, where the animal turns dangerous to human life. But this very section 11, which carves out exception, also cast a duty upon the government, because the theme of this law is to protect animal at every cost possible. So killing of the wild animal when it turns dangerous to human life is the last option. The first and the foremost step to be taken is to capture that man-eater tiger or a leopard or a dangerous animal. It has to be first captured through tranquilization. It has to be kept in captivity, and then till the time it is not relocated. So it has to be translocated to a place where there are no human dwellings, very far from civilization, if it's possible. So the law casts a duty upon the government. It is not an absolute right of the government to simply declare an animal a man eater and then pass an order of hunting down of such man eater. No. The law casts a duty upon government, on the chief wildlife warden of the state, that you have to first capture that animal through tranquilization, and then you have to capture and then translocate. So this is the duty of the government. But what happens in reality is the opposite. The scenario is almost opposite, and it has been a pressing issue in Uttarakhand, where you will see a lot of cases wherein leopards and tigers have turned into man-eater. And also, to tell you that there is a difference between a man-eating tiger and a man-killing tiger. So if anybody wants to learn about it, there are standard operating procedures which are mentioned on the National Tiger Conservation Authority's website. You can see where the NTCA, the central government agency on the conservation of tigers, the NTCA talks about how to actually find out whether the animal is a man-eating tiger or a man-killing tiger. Anyways, in both the scenarios, you would see that Section 11, when it says that an animal can be hunted, it casts a duty upon the government that you have to first tranquilize it. The first endeavor is to tranquilize, capture, and translocate. In the eventuality, if it is not at all possible, you record reasons in writing. This is what the law says to the chief wildlife warden, the government. You record the reasons in writing why it cannot be done and why the animal has to be brought down, has to be destroyed by putting a bullet in the head rather than a tranquilizer. A bullet is required. So for that, special reasons has to be accorded. It cannot be a simple rule, a general rule that the animal be killed straight away. No, because the intention of the law is to protect the wild animal at every cost. And also, when the animal is captured, after tranquilizing, the animal is captured, the government cannot keep that animal in captivity for long. It has to be translocated because the animal which comes from the wild should go back to the wild. So this is the theme of the law. So this is the first proviso. And recently Uttarakhand High Court has also given directions, because as I was discussing with you, the scenario is very much different. In few states, the state forest department would straight away kill the animal out of the political pressures and other factors. So they would not try to tranquilize, capture, and translocate the man-eater predator. They would simply put a bullet in the head and would kill. And considering the seriousness, and the forest department of Uttarakhand have actually a general rule of killing such leopards and tigers. The Uttarakhand High Court intervened last year, back in 2023, and have actually given some directions. Please move to the next slide. Yes. So you would see the Nainital High Court, the Uttarakhand High Court. Uttarakhand is a state in the Himalayas, the Western Himalayas, which we have in India. So the State High Court of Uttarakhand, which is called Nainital High Court, recently back in 2023 came up with the guidelines and have directed the Chief Wildlife Warden of the Uttarakhand state that you have to follow procedure under Section 11, and you cannot directly go on hunting and killing the wild animals. So a lot of, you would see, if you can just Google and see the number of leopards which have been killed in Uttarakhand by the government. The orders were passed mechanically that a leopard has been turned man-eater, although that leopards, you would see many of the leopards were only and only, causing injuries. They were attacking humans, but they were not eating the flesh of the human being. So the standard operating procedure in order to identify are not followed in Uttarakhand, and that's why the Uttarakhand High Court intervened. So this latest directions have been passed by the Uttarakhand High Court that you cannot simply go and kill the animals, and you cannot mechanically pass an order that this leopard X has turned man-eater. No, there has to be a thorough inquiry. After the thorough inquiry, even if that animal has been turned out to be a genuine man-eater and is killing human beings, then in that situation, you have to strictly adhere to the provision under Section 11, that is tranquilize, capture, translocate, rather than simply killing them by putting bullet in their heads. So that can't be done. So this is the latest guideline, which you can take a screenshot if somebody wants to read the entire judgment. It is the matter involving hunting down the man-eater leopard in the village Bhimtal area. The writ petition number is also available, 218 of 2023. Next slide. So yes, we have seen the exceptions when the animal can be hunted down, that is by the government, which was diseased, disabled, dangerous to human life, and standing crops. This is the another exception, one of the most important, most interesting, I would say. So we all know that we have the right of private defense, and in law we say private defense rather than self-defense. Self-defense is the layman word, the lawman word is private defense. So the law uses this word, private defense, and the law carves out an exception that in case the private defense becomes necessary if somebody lives at is peril, and somebody is apprehending injury to the life and limb of himself herself, then that person can actually take steps to injure and to kill down a wild animal while exercising the private defense. So nothing is an offense under the Wildlife Protection Act if it is done in good faith and while exercising private defense. So we all know that we have the right of private defense not only against the human beings but also against the wild animals. We can exercise private defense when our life and limb are at danger from human beings, and also when our lives are from dangerous from wild animal, when we are apprehending some kind of danger to our life and limb. So we can very much exercise our right of private defense. So one very important judgment, that's the most interesting judgment, which I love to discuss with people, and it's such a, you can say, a Bollywood movie kind of facts this judgment has. And the best part, it actually happened, and there are evidence on record of the court which goes on to prove that this happened. So we'll switch to the next slide, and we'll see about this judgment from the Northeast India, the Himalayan state of Arunachal Pradesh. The incident is from the early 60s, and the facts of the case are that Trilok Bahadur, a forest guard, he was performing his night duty. He was a forest guard in a national park in the northeast state of Arunachal Pradesh. And this national park has Royal Bengal tigers there. So while doing his patrolling, his sentry duty, he spotted a male Bengal tiger, which was very much in the vicinity. And through his experience walking in the wild, he apprehended danger to his life as the conduct of the tiger was ferocious, and the forest guard Trilok Bahadur apprehended that this ferocious tiger may charge and is roaming here and is moving in circles. What all conducts they, from there they got to know that the animal is agitated and the animal has spotted him, so he may be attacked by this male tiger, and he was all alone with his service rifle. So this man Trilok Bahadur, the forest guard, he called up his senior official, and he told the entire story that there is a male tiger who has spotted me. He's just a short distance apart from me, but I am apprehending danger to my life. And what should I do? He may charge upon me because he's not moving, out from this place from where this guard was posted. So the higher authorities, his higher official, directed him that okay, you can use your firearm, you can use your service weapon, the service rifle which Trilok Bahadur was carrying. And then they further directed that you can actually shoot in the air. So with one gunshot in the air, maybe the tiger would actually run away with the sound of the gunshot. But we all know that we don't know how the animals, in the wild animals, and mostly these predators and big animals would actually react to such sounds or maybe such gestures by the human beings. So it's very unpredictable to know how would such animal react. And this is same what happened. So this Trilok Bahadur guard, he actually opened fire in the air. So now this male tiger actually got very much agitated, and rather than running away after listening to that gunshot, he actually charged at Trilok Bahadur, the forest guard, at the night. And now, as he was having his service weapon with him, so he aimed at the male tiger who was, who charged upon him and was in very close vicinity. And luckily, he was able to take a good shot, and the tiger was dead at the spot. And later on, surprisingly, when this tiger was killed by the gunshot fired from the service rifle of a forest guard, that to a forest guard who was on duty. So very, peculiar facts. So now what happens, and this is what usually happens, you see in enforcement agency, that they would, police or forest, they would not carve out any exception that it has happened by our staff only while discharging his official duty. Tilok Bahadur was then arrested and was then charged with the offense of killing a male tiger through his service firearm. And Tilok Bahadur was then punished to 7 years of imprisonment by the trial court in Arunachal Pradesh. Then he approached the appellate court. He filed his first appeal before the Sessions Court of Arunachal Pradesh. His conviction was again upheld by the Arunachal Pradesh Sessions Court. Now the second appeal went to the Guwahati High Court in Assam, which exercised jurisdiction over Arunachal Pradesh. And there in the second appeal, the facts were discussed, the evidences were appreciated and were examined by the court. And there the contention of the Tilok Bahadur was that my act is an act of private defense. I, being all alone, attacked by a male tiger, I have used my service firearm to actually protect my life and limb. And it is not an act of aggression, it's an act of defense. So it's not that I have done any kind of offense. My act amounts to defense, not offense. The Guwahati High Court, after going through the evidences, brought on record that yes, surprisingly, this man was actually able to, bring down a tiger with one gunshot. The court held that in such a situation where a man is all alone in the wild in a national park and is faced with a situation where he encounters a male tiger and vice versa, the male tiger encounters a human being. The tiger charges and attacks, and the man is having actually some, measures to bring that animal down. Like in this case, he was having his rifle. So the court held, and it is very much there on the screen. You will see the judgment part, the last portion of the judgment. The court observes that in such a situation, any human being is not expected to, weigh the situation in golden scales. Like you cannot, very using you can't very carefully examine the situation that yes, can it be an offense? I am killing an animal. The court said you can't use golden scale to weigh the situation that by your act maybe an offense can take place. At that situation, the human being, any man or any woman, would actually think about his or her safety, his or her life and limb. So the court observed that the Tilok Bahadur was not expected to, to actually weigh the situation whether I'll be convicted of an offense, I'll be arrested, I'll lose my job, I'll be killing an animal. The court said it's an absolutely perfect case of exercising private defense. A man who's all alone is charged by a elephant and by a Bengal tiger, a male ferocious Bengal tiger. And also, what went in his favor was the first gunshot was in the air. That is actually one of the biggest, you would say, a factor which went in favor of the Tilok Bahadur, because a mere killing of an animal in a mere apprehension, killing of a male tiger with a mere apprehension that I saw a male tiger who looking in my eyes was staring and I apprehended that it would kill me, although there is a vast difference between you and the tiger in terms of distance. But a mere apprehension and then taking a gunshot straight to the tiger, killing the tiger by the single gunshot, that would actually, would somehow not be a perfect case of a self defense. It may come under the category of the offense, because there is a very thin line. Your act of self-defense should commensurate with the apprehension of injury you are apprehending. If the tiger was far off from the Lok Bahadur, and if the first gunshot was directly aimed to the tiger, it would have gone from self-defense to the case of a plain offense, that there was no apprehension of injury. The tiger was very much away from you. Why did you take the tiger down with the first gunshot? So the appreciated this fact that look, this man was apprehending danger to his life. That's why he shot at in the air. The first gunshot was in the air to make him flee away by the sound of the gunshot. But contrary happened. The cat got agitated and attacked him. So the court said the second gunshot was very much an act of self-defense, because now what Marta Kyani karta, same thing. What is now expected? The tiger is almost in the air, charging upon him. So the only reported judgment in our country, India, wherein the self-defense was held to be very much legal, and the only judgment wherein a male tiger is involved, a forest guard is involved, and a person has been accorded his right to self-defense, and the killing of the tiger was held to be an act of self-defense, not offense. This forest guard Trilok Bahadur was exonerated, was set free. The judgment of the trial court and first appeal court was reversed, and Tilok Bahadur was given an honorable acquittal. So he was given, he was set free from the 7 years imprisonment which was awarded to him by the trial court. We'll move further and then we'll conclude in 2-3 minutes. Next slide, please. Punishment. So punishment, in brief, then I'll take questions. If it's a scheduled 2 animal, the punishment would extend up to 1 lakh rupees fine and imprisonment up to 3 years. If it's a scheduled 1 animal, the punishment is from 3 to 7 years with a fine which may not be less than 25,000 rupees, which you can see on your screen. The people who are interested to read the entire punishment clause can take the screenshot and take the picture of the screen. And also any offense relating to hunting, whether schedule 1, schedule 2, which takes place in a protected area like a wildlife sanctuary or a national park, and even if a schedule 2 animal is involved, for example, wild pig is involved, it's in schedule 2, simple killing of a wild pig would be a 3-year imprisonment. But if a hunter goes into a wildlife sanctuary or a national park and hunt down the schedule 2 animal like wild pig, the punishment would be a fine minimum 25,000 rupees with no appeal and punishment from 3 to 7 years. So with that, next slide. Yes, so thank you very much for joining us for this session, and I hope the session was very much useful, and you got to learn few things about hunting. And now I'll take the questions straight away. So to start with, so there are many questions now. I think I'll pick the most relevant ones, or if I get time, my endeavor would be to take all of them. Okay, so the first question is that the definition of hunting in law is also applicable when a person or a group of persons pursue an animal for documentation or photograph. The question is asked by Miss Sonia Mandal. Is Sonia still connected?
Yeah, she is connected.
I think you can unmute all the participants. Anubhavji will take your questions in a while. Okay, so Sonia is there?
Yes.
Okay, Sonia. So your question regarding the documentation, I have not covered it in this webinar. There is one more exception for scientific management, scientific research. The chief wildlife warden can very much give permission for hunting down an animal. By hunting down, I mean what you have asked, whether you can pursue in a group uh, an animal or not. So you can very much pursue an animal for the documentation, for any scientific research, or for scientific management also, which has been defined in the Wildlife Protection Act. So under Section 12 of the Wildlife Protection Act, you can apply for the permission from the concerned forest department. Chief Wildlife Warden has the power, and Chief Wildlife Warden usually delegate their powers to their junior officers. So you can apply for the permission for the documentation or for whatsoever purpose you want, whether it's photography. So you have to explain them for what scientific research you want to do the photography, or what all scientific management and research purposes you require this pursuing of the wild animal. So we'll take. Is that clear, Sonia?
Yeah, it is. I wanted to ask that in case you are in a, you don't have the permission for a scientific work right now, you are on a safari and you spot an animal and you pursue in that case, which is not typically
No, that
for
would no,
scientific purpose.
because see, you are on safari, you only have the permission for entering the sanctuary, which is under Section
Yes.
27 if you read. So there, even in that permit, you would see there are many restrictions which have to be followed. So then also it would amount to penalty, because you've been given permission actually to go for
Okay.
safari, because that would boost tourism, and you've been given permission to enter the sanctuary, and the permission is given by the senior forest officer, but that does not mean that you can pursue the animal or follow the path. That would amount to, unless if you are accompanied by the forest department, then they would not bring a case against you.
Okay.
But factually saying, not legally. Legally, that would also be an offense. But for all this photography and everything, you need a for the permission under Section 12 if you want to do on the individual basis.
Thank you.
So we'll see, take the other next question. Would an animal killed in road accident, Vineet, we have already discussed about the road accident thing, but let me add one thing. There are different judgments from different high courts. There is one judgment from Kerala High Court which says a mere road accident in which a wild animal is killed would not amount to hunting. However, when we discuss Abhishek judgment from Karnataka High Court, it says that no, there is a knowledge on your part that you are running, that you are driving through a wildlife sanctuary. So you should, and also you should drive the car in the speed limits prescribed. So if in such a scenario, if the animal is killed, it would amount to hunting. But there is one judgment from Kerala High Court which says that no, some element of intention or knowledge should be there on the part of the accused. You cannot simply prosecute everyone uh, uh, in cases of road accidents wherein the wild animals are killed. So Supreme Court, I think, should take both the judgment and should clarify the situation, because law is very much clear. The intention and knowledge is not required in the hunting cases. So I think Vineet, your question I have answered, I think, in the fine manner, and it's clear to you what's the scenario we have right now. The second question is, in terms of animal article, both feathers which are naturally shed by the animal will be considered article in regarding the snake shed scale even outside protected areas. I think for this, for the bird feather, the Wildlife Protection Act has only carved out one exception, and that is of the peacocks. So if the naturally shed feathers are there of the peacock, only that has been made an exception. Apart from that, if there are other animals like snake shed scale or another animal, if it's naturally shed and are in the custody of someone, technically that would attract the penal provisions, because you can't take it, because only peacock has been made an exception that the naturally shed feathers of the peacock can be kept by people. but not of the other bird or snake shells. There is no provision in the law. Who is responsible for electrocution, or who will be punished if the property belongs to a group or government organization? See, if it belongs to a government organization, so obviously the department head can also be held liable, and the person who's discharging the duties. For example, if the person who has been given the duty to maintain the those cables in which the current is flowing is running, and if some negligences on the part of the government official, so yes, they can very much be prosecuted. Even the head of the government, that department, can be prosecuted. And in electrocution cases, again, it attracts the penal provisions of hunting, that an animal is killed. There are farmers who are protecting their field through this wires which are having this electricity running, and they keep wild elephants away from the farm fields. But then through electrocution, many animals are actually killed, because these people may use a higher voltage such cables to keep the animals away from the fields, and the animals are getting killed through electrocution. So any person who is in the ownership of that property where the animal is killed through electrocution, whosoever has kept that cable, like the owner of the property, the government official under whom that government office is working, so these people can be prosecuted. Poisoning is only permitted by police department to confirm. If they may be compromised, can any other entity act as legal expert to prove that an animal was poisoned? Mr. Aaron Wesley, see, poisoning in India is only permitted by police. See, no, in India, see, even in India, if an animal is killed by poisoning, the police, the forest, or whatsoever the enforcement agency is working on the case wherein an animal is killed by poisoning, the the investigating officer would send that the dead animal for the post-mortem before the concerned veterinary doctor officer, and then he would opine whether the death is caused by poisoning or not. So it is not whether the police is compromised or not. It is the government vet officer who would actually opine whether the death is caused by the administration of poison to that dead animal or not. So there is no question of police doing this investigation, because police would not do the post-mortem of that dead animal. Nor in India, police do post-mortem of the dead human being. It takes the dead body, a dead animal also, to the concerned government hospital where the veterinary officer or the doctor would perform the post-mortem. And these are independent bodies, the post-mortem performing doctor and the police authority. Now the question is, by how are the animals in the schedule 3 and 4 protected? Miss Sonia, Schedule 3 talks about the protected plant species. So there are 19 plant species currently. Earlier we had 6. After the amendment, from 6, it is now 19 plant species. They have been given protection that nobody can cultivate them, nobody can possess them without permission, nobody can get into the commercial trade of such plants without permission. Nobody can willfully pluck them from the sanctuaries and national park, because because of the protection granted to them. So Schedule 3 talks about plants. Schedule 4 talks about the CITES specimens species, 40,900 species which we have in CITES, out of which 34,600 are plants and 6,600 are the animals. So they have been accorded protection by that no person can indulge into the trade of such exotic species. So, but thing is, in today's scenario, hunting is not possible, because you would not find exotic animals in the national park, or venturing freely in the sanctuaries or other reserve forest. because they are exotic. So exotic animals are usually found in the illegal trade, which happens at the exit points of our India, at the border areas, exotic pet trades, which is the illegal pet trade happening. So we have new chapter. You may refer to chapter 5B of the Wildlife Protection Act, which is about keeping of exotic animals as pet. How you have to, register your record with the central ministry about what all specimens you have, etc., etc. So in that way, they are protected. For that, you can refer to chapter 5B, and maybe we'll take some other session on the exotic species and CITES in maybe next month or in March. Samiha Zela, is any action punishment taken or such a case considered in wildlife protection if someone tries to just pet touch a wild animal but not capture it or anything? If they are trying to go way too close to an animal to take a selfie or photograph, which says goes viral on social media and may try to encourage more people. See, these are all very much offenses. We have already, discussed about somebody going close to take any animal. So this would somehow, because see, you are very much right, as it is encouraging people to, interact with such animals, and maybe to make illegal entries in the jungles and in order to take such selfies with animals. So it is a kind of an encouragement for committing wildlife offenses. Um, and the reason is like very, it's not, it's just a selfie thing, but then again, it's encouraging more people to, venture into jungle without permissions, and maybe, to disturb the the wild state of that animal which is there. So you are disturbing them. So by your own conduct of approaching that animal, I personally think 90% would animal would be shy, would just shy out, or would take, change their course wheresoever they are found. So it amounts to driving away of animal, which is part of hunting. If by your conduct you are driving away some animal, or if the animal is that docile, it's standing, you are still taking selfies, but that is encouraging other people to, come and take selfie, and that would amount to abetment to the wildlife crimes. You may refer to section 52. It says any kind of abetment you are doing. For example, people putting pictures over YouTube. So even YouTube is abetting wildlife crimes. So last year I had the opportunity to work with the central government wildlife inspectors, and we served a legal notice to the YouTube that you are actually serving as an abetter, because on your online platform, people in India are coming on your channels, making videos and disseminating information regarding the pet trade, and they are showing cages and they are asking people to buy such scheduled birds. So you are actually acting as a better. So YouTube actually brought down 1500 to 2000 links from the YouTube. So this is the law of abatement, section 52. So yes, so if somebody is encouraging Samiha, so yes, that would amount to abatement, and that person can very much be prosecuted. And for touching also, if you're touching that animal, if it's in zoo, then it's in different offense. If it's in national park, then again it's an offense, because the forest may bring a case against you for attempt to capture maybe. Then you have to prove it was just a mere touch out of love, and we have already discussed, out of your love and affection you can't hold the wild animals. That would amount to capturing for a few seconds at least, if you are doing that. The law doesn't carve out any exception to that. Now, Sandhya ji asked, what if the roadway on which a leopard or any wild animal is crossing did not fall in a wildlife sanctuary? Does that fact have any scope in altering the outcome of the case? Yes, it may have some outcome. There are few cases wherein the wild animals would, venture out from the wildlife sanctuary, and they are found in unnotified protected areas, which are not reserve forests, no sanctuaries. They are maybe in the cities. So there maybe the court would have a soft corner, but it is all about interpreting the law. There may be judges who would interpret the law as it is, like strict meaning, the way Karnataka High Court did, that we will just go by the word of the law. It's very strict. There is no intention or knowledge involved. It's your car which is involved, and thereby you, by hitting that animal, you have killed that animal. It's a scheduled animal, so you have to pay. for the price. So you have to face the criminal prosecution. But then there are judgments which have taken some, soft corner, you can say, or maybe some more logical approach, that the forest department or the police should prove some knowledge on the part of that human being who has done this road accident and killed a wild animal. So without some knowledge, some element of malice on the part of a human being, a person cannot be simply, charged with a such offense of section 9 hunting, because he was simply driving through a road and wild animal came, and got crashed into the car and got killed. So knowledge should be proven. So there are mixed judgments, but yes, it can alter the outcome of the case very much. Depends on how the judges would, the kind of approach they have towards the wildlife laws. Sonia asks, snakes that enter into the house and needs to be rescued for the safety of both the animal and the human. What WPA laws are applicable in such situation? According to the law, capturing is punishable act. What are the laws there for snake rescue? What it can be done? So see, in cases of snake rescue, you have to take recourse of the forest department and the police department. Sadly, we don't have such SOS number for the forest department, but we do have for the police 11200 number. But we also have central government launched a helpline number for such rescues and for illegal hunting if you want to report. So you refer to the Ministry of Environment's website, wherein you will find a toll-free number for rescuing some wild animal, or if in case you want to report illegal felling of trees and illegal hunting, so that can be taken recourse of. But in case of coming to your question, snakes entering home, so the owner of the house should take recourse of the police would then call the forest department. If the forest department has a expert on for the snake rescue, then it's fine. Then they would further take recourse from Wildlife Trust of India, or maybe from some other local NGOs which they know. So, but that would not involve any penal offense, because the snake has trespassed into your house, and it's not the vice versa situation. Amardeep Singh asks, is hunting a cognizable offense? If so, it is bailable or non-bailable offense. So, Amardeep, hunting is a cognizable offense for which no permission is required from the court. The police, the forest department, the Wildlife Crime Control Bureau can very much take cognizance on the information received from their sources that hunting offense is covered, so they can straight away go and arrest that person. So it's a cognizable offense. No formal permission is required from the court of law before arresting a person. And whether it's a bailable or non-bailable offense, so all the offenses which are against Schedule 1 animals, or any offense which is done in a wildlife sanctuary or a national park, or if it's about altering of a national park's boundary, or if it is done in a core area of a tiger reserve, it is all a non-bailable offense, because the punishment is between 3 to 7 years. And Amardeep, you are well aware as a lawyer that 3 to 7 years, the punishment is in 3 to 7 years of punishment, the Code of Criminal Procedure describes that offense to be a non-bailable offense. So yes, hunting of a tiger, which is a Schedule 1 animal, is a non-bailable offense because the punishment goes up to 7 years. Same with any offense which somebody is doing in the sanctuary or a national park, it's a non-bailable offense. Question by Manan, intention should be part of the law. Temporary capture could be if the animal has entered a household, or capturing could be to save the animal to be released in wild. So animal released in wild, it's the prerogative of the forest department, not of a citizen, ordinary person. So that person should not, out of his love for the wildlife, or if he's advocating the conservation work, he should not take the, come to the forefront and take such steps of capturing and then translocating that animal without a formal permission from the forest department. Nobody should do that, and that would invoke the provision of the law, and the person can be penalized. And temporary capture would be if the animal has entered the household. So you can't obviously again see temporary capture at the household. Same the case with snake. If it's about your life, if it's about your life and limb, you are exercising your right of self defense, private defense. So you can very much capture that animal, because either you capture or you get killed or injured by the attack of that animal. So it can very much be done. But for everyone, my request is, before you obviously you capture, you keep that animal in captivity, you may lock him in some room if it has entered in your room, but you take recourse of the police and forest department rather than just taking all the initiative of capturing and then packing it and sending it, translocating it by yourself to the jungle, because then you can be arrested for illegal hunting, capturing. Then Sandhya again asks, what is the liability in cases where the reasons for the wild animal to be deceased or disabled is the negligence of the forest department, for instance? So yes, you can very much, if you have the evidence, you can very much bring a case against the forest department if any negligence can be proved, because it is the duty of the forest department to take steps for the welfare of the wildlife habitat and the wild animals. So if any disease or disability is caused to any animal and the negligence can be proved through documentary evidence on part of the forest department, so actions can be taken against officers, and a public interest litigation can very much be filed before the state high court. Thank you, everyone. I hope the session was useful for you, and we have discussed hunting laws at length today.
Maybe, sir.
And I hope to see you again. And someday we'll discuss about the other provisions of the wildlife laws. Maybe we can take up CITES and the exotic pet trade, as mentioned by someone. So thank you very much. I hope to see you guys again next month.
Thank you, everyone. Thanks to you, Lovish, for giving your precious time. And also, it was very insightful session on hunting. We learned a lot about the different ways and whatever those things are listed as a hunting in Wildlife Protection Act. Lovish just concluded the session. I guess this was a question from my very friend. So I would like to again to thank you very much for giving your time and giving a detail about the huntings. I hope we will arrange a session again on Wildlife Protection Act soon in next month, and I hope you all will be there. So thanks a lot. Thank you, everyone. Have a good day, good evening.